So, good morning, everyone, and a warm welcome to our weekly Saturday knowledge sharing webinar, which is organized by Mehta and Mehta. So, I'm delighted to have you all with us today. As a partner at Mehta and Mehta, it gives me a great pleasure to open the today's session. And today's topic is on that, that sits the right at the heart of corporate fundraisers, that is preferential issue. And for listed companies looking at, the raising capital quickly and efficiently, a preferential issue is often the procedural route. And it allows a company to issue shares or convertible securities to a selected group of identified investors rather than approaching the public at large. So, but while it offers speed and flexibility, it is also a closely regulated process, which is governed by the Companies Act for the listed entities by Chapter 5 of SEBI ICDR regulation. So, covering everything from pricing norms to lock in requirement to the shareholder approvals and disclosure obligations. So, for company secretary or a compliance professional, getting these details is not optional. It is a difference between a smooth and compliant capital raise and regulatory setback. So, this is precisely why we have dedicated session today on this topic to break down the law, the procedure, and the practical challenges, and to learn directly from those who have advised on these transactions firsthand. So, to take us through this important topic, we are privileged to have an excellent panel with us. And our presenter for the session is CSJ Pansuria. And we are joined by our distinguished panelist, Professor B. Ranganathan. So Professor B. Ranganathan is a corporate law advisor. His earlier stint was the Edelweiss Financial Services, which is limited, Services Limited, and the Tata Group. So he is a fellow member of ICAI, ICSI, and a lawyer. So he has over 35 years of experience in the corporate field and encompassing the governance, company law, investment banking, corporate restructuring, NBFC, and the like corporate law matters. So presently he advises the listed companies, SEBI registered intermediaries, NBFCs, and companies in their fundraising journey. He also serves as an independent director on listed companies. He's a member of the Professional Skill Development Committee of ICSI, and he was a member of the Company Law Review Committee constituted by the Ministry of Corporate Affairs to review the Companies Act 2013. He was a member of the Secretarial Standard Board of ICSI, and he's a senior faculty member with the various business schools, National Institute of Securities Market, NISM, and the Professional Institution. And he also delivered sessions across India and abroad. Welcome, Ranganathan, sir. And then we have a presenter, CSJ Pansuria. He is a fellow member of the ICSI and a company law graduate. He possesses over 7 years of experience in the field of independently handling the compliances under various corporate laws, listing agreement for IPO, initial public issues, right issues, IPR, and many more. So he has worked with various type of companies such as private, listed, and the government companies. So presently, CSJ Pansuria is associated with Mehta and Mehta at Vapi branch. So next, we have other panelists. I, as a partner, Nayan Handa. And then we have a Balakrishna sir, who is amongst our 4 decades with the secretarial experiences he is having and worked with the FESCO India Limited and a regular speaker at ICSI, CCGRT. Then we have a Sudhakar sir with us, so who is always a panelist. And we thank you all our panelists for today's webinar for joining us. Over to you, Jay.
I think before that, we would like to ask our panelists to give your view on the thought. I'll invite Mr. Rangarajan to speak on that topic.
Good morning, everyone. Good morning. Thanks to Mehta and Mehta for inviting me once again for this topic, because exactly a year back I had taken on the same topic. And thanks to Mehta and Mehta for organizing again this series of webinars on the issue of securities and fundraising thing. So it's nice to be here once again, and thanks. First of all, various kinds of fundraising, we all know, friends, and IPO is one thing which most of us talk these days, at least in the last 5 to 6 years. I think a lot of company secretaries are also into this fray, and a lot of the IPO market itself is booming and has really taking a shape, and it's a very hard thing to note that most of the company secretaries are also trying to do their job as a part of the IPO process. While we talk about the IPO process, for post the listing, companies do resort to further issues in the form of a preferential offer. Now, looking at different regulations, it seems that IPO is a very toughest job. But once you look at the preferential issue guidelines, the regulations, I think a lot of things. My request is, all these questions, if you can post it at least after the introductory stage, please. Please wait for another 5-10 minutes and then you can start posing your questions. Humble request. Okay, so the preferential offer or the issue seems to be very simple. In terms of regulations, it is only some 12 regulations that we need to, but each one has got its own importance. Each one has its own importance, friends. And what typically happens is while we feel it is very so easy, if you go and look at the ICDR regulations, each line has to be read very carefully before we try to do or try to start the activity, the corporate action with respect to the preferential offer. So even before that, let me tell you a couple of friends, let me tell you. So in that way, the preferential offer or the preferential issue topic is something which you and I as company secretaries or whoever is working on the deal, humble request is first read the regulations. I think most of us, what we try to do is we try to read a lot of articles, a lot of, other stuff. We don't believe in yourself and we ask the chat GPT to give us all the details first. I think as professionals, I would feel we should not do that, friends. We should first read the regulations, understand we're all qualified people. We know what is there. Just read what is there in the regulations. The second aspect is connect the dots. It's not only the ICDR, but also there is another Companies Act, which we need to completely follow in this regard. So read that act, the particular provisions which are available. See, but the main problem with us is we don't do this, but we get into the earlier, if somebody has already issued the preferential offer, we just to try to log into them, and just to try to, copy paste whatever there. Please let us avoid that. Maybe you can get a clue, but after your analysis, do that, friends. My humble request, do that. So the topic is a very important topic. Whenever you try to handle the preferential issue, please, my request is read ICDR, especially listed entities, read those lines carefully before you embark on this journey of preferential offer. And the second, which I always reiterate the point is, we as CS people are very good or the best interpreters of corporate law. Let us have confidence in that, please. So with that small note, friends, this topic is a very good topic, and let us be very careful whenever we are dealing such kind of a thing, because let's not just simply ignore saying that it's a very small thing which can be completed in a few days of time. No, this has a lot of learnings for us. While we discuss, I'll also talk on some of the case laws, how we as company secretaries have to be careful and also contribute to this journey of the corporates in their fundraising activity. That's my introduction, sir.
Thanks a lot, Rangarajan. Let me welcome you all for this webinar on my own behalf and also on behalf of Mehta. As you have been aware that we have been conducting series of webinars on the fundraising issues and listing on the main board. That is what we have been actually doing it. Having discussed initially the equity share and also the right issues and preferential those things, now we are talking about the preferential issue. As Rangarajan said it, yes, it is a very small chapter. And this is probably people do it because it is quicker. We don't have to go in the elaborate, regulatory delayed procedure like in IPO. It is only the select group of people, identified people. Maybe the reason for doing this is different. That we have to understand. As Rangarajan puts it, since we are going to be a corporate law, corporate advisor, strategic planner to the board members, we need to know the purpose for which it is done, why it is done, what is the best way of doing it. That is what we need to do it. Because many times what happens, a company wants to infuse the capital very swiftly. That could be one of the reasons. Or otherwise, they wanted to have the strategic investor to be associated with them. And at the same time, they wanted to retain the promoter control Strategically, they don't want to lose it. Could be there. There are a lot of companies which we have seen in the past also. They are also doing a lot of debt restructuring, adopting things. So this method definitely a very, very cost effective method. And identified people could be institutions, venture capitalists, even at time promoter if they want to keep the control with them. All those things which are actually there. But only thing is, here what happens is we are dealing with the two sets of companies. One set of the companies, all the companies which are coming under the company side, they are not listed. But there's another set of companies who are actually specifically listed with the stock exchanges. So there are two different regulations which we are going to deal with it depending upon the company in which we are actually going to exercise this option of fundraise. Because as per the Companies Act, it is applicable to all the companies. But in case of the listed companies, the ICTR regulation is specifically applicable, which has got a little more stringent regulatory framework compared to the company side. That is what the nitty-gritty is there. But the only thing is, yes, we are trying to get over the regulatory delays, get into the quickly, but in the process, as Rangarajan puts it, we tend to miss out certain things. That is where he said that we will take up some case laws, etc. Nothing, what has gone wrong, what is the thing, etc. That is what it is. That is where our core knowledge actually gets applied. We'll have to work. We'll have to understand the fundamental. We'll have to create a checklist. We'll have to ongoingly monitor and ensure the absolute compliances so that we don't land up any problem. That is the issue. Mr. Rangarajan, I know him. Not only today, I know him over more than three and a half decades. Actually, my association goes back to Navi Mumbai when I used to travel to CCGRT that time. I think Rangarajan, for the first time I met him, he was actually heading the Bombay chapter of ICSI. It was functioning there. He was a chairman there. Actually, he organized a lot of webinar also at that particular time. He has invited me also there. From that time onwards, I know Mr. Rangarajan. He is a veteran in this field. He is practicing over three and a half decades on this. I would say he is not a person who, believes certain things in writing and delivering and nothing. He is a extempore person. Anything you are waking from the sleep, he will immediately tell you, oh, this is the section, this is the regulation, this is what it is required to be done. That is what he will say. That is the person he is actually. So for this particular session, we could not have none other than the better person than him. I'm expecting his practical experiences, how to deal with the nitty-gritties, etc. That is what I expect at this particular session. I'm very sure I will get enlarged, my knowledge enhanced, because I'm little bit of a, elderly person. Although I am keeping in touch, but I know the theoretical, but practical I do not know. So when it comes to the practical aspect, definitely Rangarajan's sharing will be of immense use to me. I'm also sure it will be practically the same for the other participants also. To be very frank with you, Rangarajan, you see, the urge of learning, knowing the things actually growing with the youngsters, which is really, really enlightening me like anything. I am really, delighted to note this. If you see now, we are actually having about 140 plus members who are actually present eagerly, who are waiting to hear from us. Even I think more people will join because there is a tendency. People want to skip out the introduction, they want to join. That is also there, which is seen in the recent past. I think I stop here. I will not take much of a time in this. I will ask the presenter to start presenting it. As usual, please put up your queries and questions on the chat box. That is number one. Please avoid any particular personalized issue based to your organization, because this forum is categorically interpreting the law, sharing the ideas, do's and don'ts, procedural issue. This forum should not be construed giving an opinion for your particular solution of the problem, which I would like to put a disclaimer at this particular stage. That is what I would like to mention it here. Please avoid doing any particular issue very specific to your organization that you may have to get in touch, because we will not be able to answer all those things without knowing the full facts. That is the thing. Okay, with this, I ask our presenter to start his presentation.
One
Over
thing,
to you,
sir,
please.
Good, sir. Good introduction, and thanks. And very nicely you said, it is not an opinion-seeking forum. I think that is the biggest thing that you put it across. Secondly, 153 people I'm seeing participants. Though it doesn't have neither structured hours nor unstructured hours, people are attending. So thanks to each one of you friends for sparing your time and wanting to listen or whatever. I think it's a good number that has turned out. And thanks for coming in, and please let's get into the discussion of the day. Over to you, Jay.
Yeah, thank you, sir. Thank you, everyone.
Rangarajan, in fact, you are free to interfere at any point of time, share your things very freely. That is number one. Number two, although chat box will be taking it is open to you also. If you feel something is relevant, you can also have a view at it. You can also address. I have a privilege. Sure. You have a privilege to do that.
Yeah, definitely. The only thing, Jay, are you going to start?
Yeah. Yes, yes, just 2 minutes.
I think let me also, in between, let me just, I wanted to show only one slide, and then I think.
Yeah, please.
Jay, now it's almost today, we are in, 2026. The 2013 Act has come, and it's now 12 and a half years since the new Act has come in. It's not a new Act. Now 2013 Act is in place. But still, I find a lot of people are confused with what is the difference between private placement and preferential offer, friend. So I just wanted to show you initially one slide. I think let's take that as the base and then get on to the things, please.
Sure.
Only one.
Give access to Rangarajan to share his screen, please.
So friends, I think most of us know. Even then, let me just reiterate. Now, private placement is it's an enabling section which allows you to do so many things. So first and foremost is the private placement. Everything is a private placement, and others will fall under a subset of the private placement. Let's first put that way. Now, when it comes to preferential offer, it could be for listed entities as well as for unlisted entities. So if it is unlisted entity, you are purely governed only by the Companies Act, whether it is private placement or a preferential. But when it comes to the listed entities, you have two sets of preferential offer in a listed entity. One, which could be a preferential issue, and the other could be a preferential issue in the form of a QIP, wherein only the QIBs will be the prospective allottees. So please let's understand. Now the first point is private placement. As I said, it's a mother of all the preferential offers. That's why if you look at Companies Act, Chapter 3, which talks about issue and issue of securities, it's divided into two parts, Part 1 and Part 2. Part 1, if you see, it's purely focusing on the IPO front, starting from 23 to 41, with IDRs. Then if you took Part 2, it focuses only on the private placement. Now, what's the main difference between private placement and preferential offer is, under a private placement, you can issue any instrument, friends, which includes your NCDs as well. I think that is the crux when you talk about a private placement. You can issue any kind of an instrument, including debt instruments, under private placement. First, let's understand this. Then what is a preferential offer? A preferential offer is nothing but whenever a company wants to issue equity and any convertible securities that is convertible into equities, then you need to follow preferential offer sections and the guidelines. So a preferential offer is nothing but a subset of private placement. Now today, just to tell you, buyback has a different provision, capital reduction has a, but if you actually see, buyback is a part of capital reduction, right? So that is how we need to first understand private placement is a mother of all the preferential offers. And then you have a subsection or a subset of a private placement, which is the preferential offer. And let's please understand, preferential offer is only for equities and convertibles. Private placement is for all. Second point that we need to remember is whenever you are doing private placement, that is section 42 lists down the steps or the various process, also certain process to be followed in case of a private placement. So when you are doing a preferential offer of equity or convertibles, you should read that section 62 along with 42 in terms of the procedural requirement. For example, the private placement offer, opening of separate bank accounts, etc., is what you need to know. You need to read. Now, we have been emphasizing, focusing on this and saying that preferential offer is one of the easiest way of raising funds for the corporates. Also, friends, please bear in mind, under the Government of Companies Act, if you see liability of directors, you can come liabilities of KMPs, you will come across in different places. But very rarely you will come across the liability of the promoters as well. And one such section is section 42, friends. Here the promoters are also will be held liable. And it distinguishes between, if you look at preferential offer, recently I think ROC had issued an order distinguishing between the penalty under section 42(9) and section 42(10). So a lot of things are happening. So let us be careful while doing it. So sum and substances, private placement is you can issue any instrument under private placement, including NCDs. Preferential offer is equities and convertibles. For listed companies, you have preferential issue, and when it is being made only to QIBs, it is called QIP. So this is what I just wanted to first set the tone, and maybe later on, we will keep analyzing the things, friends.
Thanks a lot, Rangarajan. Thanks a lot, Rangarajan. One particular point you actually drawn. Initially also you said, let us understand the regulations. When you touch upon this issue, I would like to only touch upon one particular section, that is section 62. When it comes to section 62, what happens is we don't read. Instead of complying with the section 62(1), we comply with section 62(1) subsection C. When the regulator comes to us, no, section 62(1)(c) calls for, elaborate disclosure which I have made, that as good as I have complied with section 62(1). Regulator says, sorry, you are not complied with section 62 subsection 1. That's all. Who asked you to comply with section 62(1)(c)? There's a wonderful order has been passed on this by the ROC, saying that although he says I have complied more than what it is required, but the point is what is required is not complied with. What is the use of complying more than what is required? That is what it turns out. So from that perspective, it is very, very important. And second thing is, when you touch upon these issues, very important. Many a time when you are complying with the section 42, we cannot ignore section 62. That is the issue. So that will have to come very, very clearly. That has to be understood. That is the nitty-gritty. The whole section rounds out only these two sections, only the whole issue, along with the disclosure requirement.
Yeah. Okay. One more thing, Jay, one more thing I just wanted to add here. Sir, there has been a lot of queries which people raise. Conversion of loans into equity at a later date. Whether this is a part of your preferential issue. I think, what friends, my humble request is, if you look at 62(3), it talks about a situation where conversion of a loan or a debenture into equity, provided this has been agreed and is part of the terms and conditions at the time of sanctioning of loan or NCDs. I think many companies forget this, and whenever they want to convert this, they end up in a problem. So please, you will get an exemption, or it is allowed only when your terms and conditions of the issue of NCDs or a loan contains a very specific condition that it could be converted into a loan at a later stage based on a contractual obligation. Please ensure that if that is the case, even otherwise, whenever you have this kind of a loan or a debenture, depending on the promoters' interest, on the promoters taking them into confidence, if you have this kind of a provision upfront, maybe it will save you at a later stage whenever. So please be mindful of this. In fact, ICDR starts very beautifully with this conversion of a loan concept. If you look at regulation 158, so as and when it comes, I will tell you. But this is one thing, Mr. Balakrishnan, I wanted to highlight at this stage, because a lot of companies, a lot of people ask this, and unfortunately they don't have a provision at the beginning, and which has not been approved by a special resolution. That's why I just wanted to highlight upfront so that I don't forget. What do you, Jay? Sorry.
Absolutely, you said, Rangarajan, well said actually. In fact, in the earlier forums also, we have many times talked about it. Whenever you are drafting a document, please have a long-term vision of the document. Take all the care visualizing, which may or may not occur in your time. That is what we have said in the past also. Similar is the case in this case also, unless until at the time of entering, if it is not agreed upon, later on, if you want to do it, it is going to be very difficult. Yeah, well said, really. Yes, or Jay, it is your time now. We have taken enough time of yours.
Unmute. Jay, please unmute.
Okay. Yeah, so good morning, everyone present here. And today we'll be discussing on the topic preferential issue. So these are the basic topics which we'll be covering, like basic concept of the preferential issue, Company Act 2013, SEBI ICDR Chapter 5, pricing mechanism, lock-in, and a few of the case laws. So first I will like to brief out that what is a preferential issue. So as per section 2, as per regulation 2 NN of SEBI ICDR regulation 2018, preferential issue means an issue of specified security by a listed issuer to any selected person or group of person on a private placement basis in accordance with Chapter 5 of this regulation, and does not include an offer of specified security made through employee stock option scheme, employee stock purchase scheme, or any issue of sweat equity shares or depository receipt issued in a country outside India or a foreign security. So if I break down, then securities issued, so it should be equity shares or fully or partially convertible debentures, warrant, or any other convertible instrument. Then who should be the allottees? So it should be a promoter group, QIB, HNI, identifiable person. A maximum it should be 200 in aggregate per financial year as per the Companies Act. The governing section while doing the preferential issue, it will be section 42 and 62 of the Companies Act, chapter 5 of the SEBI ICDR, and if there is any foreign securities, then it will be covered under FEMA for FPI or FDI. The benefit of raising fund through preferential issue is that the company will get a quick capital infusion without IPO process, a lesser disclosure, and a targeted investor base.
Rangarajan, I wanted to ask you one question. When you are talking about the allottees, when you are talking, the number cannot be more than 200 or something like that when we are talking about it. Nowadays, with the digitalized era, there are a lot of platforms which are actually offering that we can actually helping you to reach the people, etc., and other things and all. That is actually there. So what happens is, I have seen a case, that is why I'm asking this question, I wanted to bring to the notice also. What happens is, one such case, it is like that, they have actually offered, the board is considered, including independent director who were there on the board. The online marketing was actually approved. Ultimately, what turns out of the tragedy was the number exceeded much beyond 200 due to the online, which nobody had taken care of it. With the result, the liability has occurred to all of them, including the independent directors who were actually party to the decision. That is what it has happened. So when we are talking about all these things, yes, digitalization is good, but at the same time, we'll have to weigh the pros and cons and other thing and all. We'll have to take care. That one precaution you'll have to take care. That's what I think. What is your experience, Rangaraj?
No, I think you are absolutely right. There are a lot of platforms which offer this, but when you look at from a company's angle, when you look at a company's angle, what does it say? It says that to whom are you offering? No, I'm not offering it to the platform providers. I'm offering it to XYZ who have to be identified upfront. And when I'm giving it to say A to whatever, A to L or A to M, some 15 people, I have to, when I'm giving the private placement offer, I have to serially number also. See, the serially number everything, and I should give only to those people, and they have to, and only they can be the allottees, prospective allottees. So if these kind of platforms which are coming in, I think the investors should be cautious about this. Rather, the platform providers should very clearly indicate. Ultimately, what can happen is if I'm such a provider, if I have, say, around 50 odd people who had come into this, then I need to, give that list to the company, and the company in turn can directly allot to them. That's the only way we can monitor this. Now the entire friends, the crux of this section 42, the genesis of section 42 goes back to Sahara, right? I think otherwise.
Yeah, right. Absolutely right.
So 2013 Act would not have a separate, section called section 42. Because earlier under the 56 Act, you had only section 67 subsection 3, which said that any offer to more than 49 people will be deemed to be a public issue. Okay. And hence, in this case, that is why later it was very clearly mentioned that everything should be serially numbered, so that I know to whom I'm allotting. If you look at the explanatory statement, what is that we need to do? We need to identify the persons to whom are we giving, Hence, sir, just to answer you, maybe, when we are talking about this, the digital platforms, they cannot directly come in. Maybe the subscribers list, if they are able to share with them and the company directly offers to them, then that will be. Otherwise, it is all, violation of the company's
Not only
act.
that, in this particular case, the company went on arguing, saying that, it is not our mistake, it is actually the mistake of this online platform people. Why don't you take action? They said, sorry, unfortunately, they are not covered under any of the act. We cannot take any action against them. The only act what we can take is identified people who are coming under the Companies Act. That is all. We can't take any action against them.
Is this a Delhi-based company? If I
Correct. Haryana.
Yeah.
Correct.
Yes.
It is actually the Plenty platform or something like that.
Yeah. I think it happened in
25 platform, something like that. Yeah.
21 or 22 it had happened. Yeah.
Correct.
Okay, so now let's understand the basic fundamental of the Companies Act. First, we will be discussing on the section 42, prior placement, which says that offer should be maximum to a 200% per financial year, excluding QIBs and employee under ESOPs. The application money must be received through check, DD, banking channel, etc. It should not be in a cash mode. Mandatory requirement is to open a separate bank account, and before a company files PS3 form, the money should not be utilized for its object. Then, as per Companies Act, the allotment should be made within 60 days of money receipt, or else the company need to refund it within 15 days with a 12% per annum interest rate. And offer letter in PAS for should be circulated within 30 days of filing MGT 14, and it should be recorded in form PAS 5. If there is any violation of the section 42 of the Companies Act, then the penalty will be 1,000 per day, and it will be maximum to 25 lakhs. And contravention of any rules or section, then it will be lower of the amount raised or the 2 crore.
Okay. So Jay, just wanted to say this, when we talk about, friends, when we talk about 200 people per financial years, two things are excluded. One, when you are offering it to the QIBs in a particular year, and because QIBs, the latest regulation talks about, you can offer QIPs every 2 weeks. I mean, the gap between two QIPs should be only 2 weeks, minimum of 2 weeks. So in such a case, I can offer it. Hence, there is an exemption. ESOPs are also being considered because during the year you do not know, because exercise by the employees can happen at any time, and if in a year more than 200 comes, exercise their options. Hence, that exemption is given. Now, the new corporate, the company's amendment bill, which will come into force whenever it is notified, also talks about including along with ESOPs, the what you call as RSUs, the restricted stock units, and the stock appreciation rights, because different nomenclatures and different forms of ESOPs have come into play, and hence you will see the new amendment. After the amendment, you will also see those kind of things as a part of exemption to this 200% in your financial year. Yes, Jay.
Second section which we need to take care is section 62, subsection 1, sub C of the Companies Act 2013. which says the issue of shares to be a person other than existing member or employee under issue. It also says that it requires a special resolution for both listed and unlisted company. The price determination is as per Rule 13 of the company's share capital and debentures rules, which we'll be discussing in the upcoming slide. Register valuation report is required for the unlisted companies. The offer period timeline is minimum 15 days and maximum it should be 30 days for unlisted companies. But for private limited and IFSC public company, there is an exemption that if there is a 90% of the existing shareholders given approval, then offer period can be minimized. Offer and application shall not carry any right of renunciation. For unlisted company, the allotment shall be completed within 12 months of the passing of the special resolution as per Companies Act.
One second, friends and Sir Bala sir. Now, very peculiarly, Section 42 talks about offer and application shall not carry any right of renunciation. See, renunciation is a part of your rights issue. I don't know why this is script in Section 42 saying that, it doesn't carry a right of renunciation. I mean, just wanted to tell you that, why this is script in. At least I'm not able to understand this because it's a right of shareholders under the rights issue. Go ahead, Jay.
Okay, so let's understand the procedure and rules as per Rule 13 of the Company's Share Capital and Debentures Rules 2014. So whenever a company is planning to raise fund through private placement or a preferential allotment, the first more thing is to have a board meeting wherein they will approve the proposal. They will fix the date for EGM or a postal ballot. Pricing terms and condition will be decided. Then a notice along with the explanatory statement will be issued to the shareholders for the approval. Once the resolution is passed, either in EGM or a postal ballot, it has a validity of 12 months. Then after MGT 14 need to be filed within 30 days of passing the special resolution. Then for unlisted company, the private placement offer letter, it should be circulated within 30 days. The money should be received only in the separate bank account, and allotment should be done within 60 days and file pass 3 within 15 days of allotment. Until the date of allotment, the company cannot utilize the fund. Now, the key requirement under Rule 13, we discussed that a special resolution has to be filed. For listed company, there is a compliance to be taken care under Section 62 1C and plus Chapter 5 of SEBI ICDR. The issue must be authorized by the article of the company, or else we need to amend the article of association first. The price shall be determined by the registered valuer, and a valuation report is must required. For convertible security, the price shall be determined upfront at the time of issue, or it can be decided at the time of conversion, but not later than 30 days. If preferential offer is for non-cash consideration, then depreciable or amortized assets, it should be also taken care, and necessary disclose as per accounting standard shall be done in the balance sheet.
Okay, Jay, just, friends, if you look at the requirements under Rule 13, issue must be authorized. It is not that particular issue that is required to be authorized. The articles of association should carry a very specific provision saying that the company at any point in time can raise money through preferential offers. I think, friends, most of us would be in the practice. So whenever you incorporate a company, please ensure that, this aspect is already included. So it's one-time inclusion in the articles. It's not for that particular issue, but for, for any company to do that, it's the provision that is required to be incorporated. So when you do an incorporation, ensure that this provision is already there so that you need not have to waste your time in altering the articles.
Okay, so now we will see the Chapter 5 of the SEBI ICDR Regulation 2018. So if we talk on the eligibility and applicability, then it applies to all the listed company who is issuing shares or convertible security on preferential basis. Issuer equity share must be listed on a recognized stock exchange. No winding up or insolvency proceeding should be pending. And promoter or director should not be declared as a willful defaulter by any bank or financial institution. No SEBI department order against the issuer promoter. It in principle, approval from all the stock exchange where the shares are listed is mandatory, and a certificate that company has complied with all the regulation of the Chapter 5 is to be certified by the practicing company secretary. And shareholder approval is mandatory. Application to the stock exchange has to be filed on the same day when the notice for the preferential issue is sent to the shareholder. Now, what are the permitted instrument and allotment? So, under preferential issue, the permitted instrument is the equity shares or fully convertible debentures or partially convertible debentures. Then, if the no allot, then we will discuss on the monitoring agency. No allottee have sold or transferred equity share during 90 trading days preceding relevant date, except interstate transfer. Now, what is the relevant date? We will be seeing in the next upcoming slide. So, if the preferential issue size exceed 100 crore, use of proceeding shall be monitored by the credit rating agency. The monitoring agency again is not applicable for the banks or public financial institution or insurance company. In case if company has appointed monitoring agency, then quarterly report has to be submitted with the stock exchange till the funds are 100% utilized. The timeline for the report that monitoring agency shall be issuing 40 day for within 45 days, and it should be uploaded on a company's website and submitted with the stock exchange where the shares are listed.
Okay, just to highlight certain things here. The eligibility, whether a company can do a preferential offer in case of a listed entity. First, when you talk about the eligibility, first and foremost, one, equity shares are listed on the exchange. That's fine. The second aspect of the companies, it should also be in compliance with the LODR things. Please ensure, friends, the LODR compliance is also continuous compliance with the listing regulations is also a mandatory thing for a company to come out with, before they launch or before they get into a board resolution. So that is one thing which you should be keeping in mind. Secondly, SEBI department is fine. Thirdly is, even if he is a willful defaulter or a fraudulent borrower, you can still come out with the preferential issue provided you make adequate disclosures as mentioned in Schedule 6 of ICDR. There are certain relevant disclosures that are required. But if you are a fugitive economic offender, you cannot come out with a preferential offer at all. I just wanted to highlight this point. Secondly, friends, please understand this entire preferential issue, the compliance with the entire provisions of the preferential issue should be certified by a practicing company secretary. Earlier, it was only the statutory auditors who were given the powers. I think thanks to our the council members who fought very who got this valuable recognition for us. So friends, even if you are on the practicing side, you need to ensure that each and every part of the regulations is adequately complied with. That certificate is to be given. So in terms of diligence, please ensure that you are doing it in the right manner is what I just wanted to tell you. And the statutory auditor's certificate is only with respect to ensure or to confirm that the payment has been received from the bank account of the prospective allottee. Hence, statutory auditor's role is only restricted to that aspect. The second one, under what are the different instruments that you can issue under, as we spoke initially, private placement can issue anything, and under under the preferential offer, you can issue equity and convertibles. Now, Bala sir, can I take one question? Somebody.
Yeah, sure.
So that
Sure.
it will be easy instead of, I think
Sure.
right from the beginning, I requested, does warrants come under the definition of convertible securities? Yes, it is a convertible securities. To answer first one. Second, then why is it mentioned separately in various regulations? Now the question is, when you look at the feature of a warrant vis-a-vis any other convertible security, whoever has asked this, is that in a warrant, the features of a warrant is completely different. In a convertible, what happens? You have a tenor, you have a fixed coupon rate for some time, and then it at the end of the tenor, you just convert that into equity shares. I think the simple thing. But in a warrant, you have slightly a different. So you have a different dimension to warrants, where though it is, you don't call it, it is a convertible instrument, but look at even the regulatory or the legal language, convert into equity vis-a-vis excise equity shares. Like ESOPs and warrants, you should always use the word exercise. That is one. Secondly, in case of warrants, you pay something upfront, and then remaining one you bring it at the time of exercising the option, right? The third factor that goes into the warrants is, if you do not pay this 25% is in a listed company, you collect at least 25% initially. So when you collect this 25% initially, where is it shown? It's forming part of your shareholders' funds, right? Whereas if you issue a CCD or a CCD, you show it as a liability, right?
Some cross-talking is taking. Can you unmute, please? Whoever is there.
I think Jay should mute himself. Jay should mute himself. Yes, thanks. So third one is it is a part of your shareholders' funds, and hence the fourth one is, if you do not pay the balance of the 75%, it gets forfeited. Whereas you will never find these things in other convertible instruments. And that is the reason, even in terms of a lock-in period, when you talk about in a listed entity, the requirement is completely different. And hence there is always a specific mention about warrants. I'll also take this opportunity, Bala sir, to tell, is in a QIP, when a company is making a pure QIP, there is one instrument that it can always offer. I think some of us might be knowing this, NCDs with warrants. It's a very peculiar instrument, where on one hand you have NCDs for some time, but it also is accompanied by a warrant instrument, and hence from a company's angle, the NCDs, when you fix the interest rate, it's slightly lower, because in a few months' time, you are going to be a part of the equity shareholding fraternity, and hence it is being priced at interest is slightly lower. So there is a NCDs with warrants is also a concept under the QIP, and hence you will always find, just to sum up, you will always find warrants to be different. Even in FEMA also you will find the word warrants different. So valuation report and all, we will just come. Can warrants be issued in physical mode? Can warrants be warrants? Warrants are transferable instruments. There is no hard. But whether you can issue in physical mode, if you will have to trade today, all the securities have to be in dematerialized mode. It has to be in a dematerialized mode. Even, for example, in fact, if you are in a listed entity, you have to issue only in demat mode. There is no other way. There is no other way. So somebody was asking about NCD cannot be converted into equity. I have already replied, but just to tell, Krishnan has raised this, just to tell Krishnan that under 62(3), a situation has been contemplated, and I think most of us would have been dealing with loan covenants, right? Where it says, in case of event of default, the lender has got every right to convert this into an equity shares, right? So, it need not, whenever it forms part of the initial conditions after some time, it can be converted. Normally, NCDs are non-convertible. But today, even when you forget about 62(3) or forget about any loan covenants, even if I'm issuing NCDs, after some time with the consent of NCD holders, I can convert into a convertible also. But this situation is different. It is in the form of a loan or a debenture, but the conditions have been put upfront, saying that I have the ability to convert into equity shares in the event of default. Or in fact, if you read section 62 subsection 4 of the Companies Act, loans or debentures which have been given or subscribed by a government, in the public interest, they can at any point in time convert into equity. Okay, Mr. Krishnan. So I have already put it in the chat box. So that is one thing. This Harish, if you can just tell me when this has come, rights and
There are questions.
No, just whatever is possible at this stage, I'm covering, sir. The linkage of preferential issue as a part of a rights
No
issue.
problem.
Just I need to think over it, but just if you have anything, please. Latest amendment, I'm not sure whether there is an amendment to this, but if you could just tell me what it is, then we can always. When to apply for in principle approval, I have replied it has to be simultaneously. I think Jay also mentioned. In fact, he has mentioned application must be filed with SE on the same day when the notice has been sent to the
in
shareholders.
principle approval need to be applied on the very same day when you send the notice of the AGM to your shareholder for seeking the approval. As Rangarajan puts it, kindly go through the regulation. It is even I have seen some questions whether MGT 14 is required to be filed. MGT 14 is a must. It is a filing requirement. Within 30 days of passing the resolution, it is required to be filed.
No, I'm not going to answer.
All those things, I think, fundamental thing. We all should know all these things, I think.
So anyway, very good questions have come, sir. Please allow me to raise it. To answer it right at this stage. Whether fund collected from issue of warrants,
yes.
As I explained some time back, a few minutes back, it is forming part of your shareholders, friends. Please, I would request you to go and see Schedule 3, right? So once it is a forming part of your shareholders funds, it can also be considered as a net worth. There is no doubt in it. You can consider how to guide the company, what to go for private placement or a preferential issue. So it depends. It depends on two things. Depends. Private placement. Why do you want to go? It's nothing but a comparison between a debt instrument vis-a-vis an equity or a convertible instrument. Kuntal. I would say that you weigh between the pros and cons of a debt instrument and an equity or a convertible, and then accordingly decide depending on what the company's requirement. Whether if it is a debt instrument, you will have to give collaterals, you need to pay interest. But if it's a convertible, you need not have to do that, and it will not form part of your deposits. So all those things, depending on what the company's debt position is, and depending on the debt equity ratio, also decide on those things and then advise them what is the best way. And when you talk about a preferential offer, will there be a equity, or are you giving it to an outsider? Then there will be a dilution. So you need to advise the promoter to that extent. There will be a dilution. And if you are giving it only to the promoter, it's increase in their holding. Accordingly, just put the pros and cons and then decide. Okay. So yeah, please. I think.
Jay, go ahead.
Okay, so here we'll be discussing on the QIBs, that QIBs having following rights, that which will be deemed to be related to the promoters, like shareholder agreements, right? If they are having voting agreements, right, veto power, and right to appoint a nominee director. So in QIB, there will be equity shares, non-convertible debentures with warrant, convertible securities other than warrants. And here the relevant date will be 30 days prior to the date on which the holder of warrants are entitled to apply for the equity shares.
Well, sir, if you permit me, at the end of preferential, when we finish the preferential, I'll just take 5 minutes on QIP, because many listed companies do come out with QIPs. I'll just focus on that as well.
Sure. Sir,
go ahead.
The whole platform yours, because we are interested in sharing your knowledge, because we always believe, wise people learn from others' experience.
Sir, it is always mutual. It is always mutual.
No, it is always the case. I said initially, there are a lot of things I will also learn. There are a lot of things you will also learn. There is always a mutual, it is ongoing. Because learning is going to be till we go to the graveyard. There's no
Sir,
doubt about
let
it.
me tell you, one of the, I think the best question that has come is whether it will be considered as a part of net worth. The finance guys used to ask. Very happy to note somebody is asking this. And another question, why warrants are treated when it is convertible? These are the things, friends, really appreciate this, some of the questions. And, this is the way we have to start thinking. And if you start thinking, I think, and as I said at the initial stage, we are the best persons to interpret corporate law, have confidence in us, in ourselves, friends. Go ahead, Jay.
Now we will be discussing on the
Okay.
pricing mechanism under regulation 164 of the SEBI ICDR. So first we will be talking on the frequently traded shares. So what is a frequently traded shares means the traded turnover during the 240 days preceding the relevant date is at least 10% of the total number of shares where share capital of a particular class is not identifiable. Then the weighted average number of total shares shall represent the total number of shares. So if the equity share listed for more than 90 trading days or more, then the price shall be higher of the following: 90 trading days weighted average value price preceding the relevant days, or 10 trading days of the weighted average value price preceding the relevant date. If equity shares are remain for less than 90 trading days, then the price shall be the IPO price or the scheme value. The scheme value means if the any scheme has been approved under the BIFR or any NCLT plan has been approved, then or the average weighted value average price during the actual listing period. Now the key points to be taken care while the price mechanism is pre-computation required after completion of the 90 trading days from the listing. So if the company is falling below the 90 trading days, then once the 90 trading days is crossing, then again the computation is required. And if the issuer has paid higher price, then the difference shall be paid to the allottee. If article of association prescribe higher price, same shall be considered as a floor price. So next will be on the preferential pricing mechanism for the QIB.
So now 1 second. Okay, you just finished. Chalo. This slide, after this slide, I will take.
Okay. So maximum 5 investors. The pricing should not be less than 10 trading days of the weighted value average price preceding the relevant date. And the restriction is that no allottee directly or indirectly to promoter or persons related to promoters.
Okay.
There is one interesting question has been put by Mr. Krishnan. Krishnan says again, monitoring agency. Utilization of the proceed to be monitored by the credit rating agency or audit committee or the company or end use certificate to be issued by the statutory auditor. It's a very good question, I would actually say here. Because one thing is there very clearly when you are talking about the listed entities, the utilization proceeds really required to be monitored by the credit rating agencies, actually by CRA, that is one. But at the same time, audit committee is holding a total responsibility for reviewing these reports. Because audit committee is the one who's holding the responsibility of overseeing this report and satisfying the fund usage for themselves. That is one thing. But in the process, what happens? They take the help of the statutory auditors to see that fund usage is actually correctly done. That is what, because all are actually interlinked. It cannot be, standalone. Only CRA will do it, audit committee will do it, or statutory auditor will do it. I don't think that will be the case. Rangarajan, your view, please.
Yeah, I think you are right. Right, sir. You are right in saying that first and foremost is the credit rating agency, which is the monitoring agency, will issue a report to the audit committee to review that whether the utilization of the funds as contemplated in the in the objects of the issue has been done. And if there is a deviation, you need to report under section regulation 32 of the LODR. So audit committee is only reviewing mechanism for what do you call the statement presented by the monitoring agency. The only thing which I just wanted to tell you, since you raised the issue of a statutory auditor, the role of a statutory auditor comes in under regulation 32(5). If you see it has to prepare an annual statements of funds utilized, for, whenever, that is the only time when, and the auditors also have to give a certificate to the audit committee, saying that what is the utilization of funds till this stage. Okay. So, sir, that's what monitoring agency giving it to the audit committee and the statutory auditors annual statement of utilization of funds. These are the three things that, I would feel. Okay. Now, can I take,
Sure.
So, Jay, allow me to show one small clip, please.
Sure.
When we're talking about the pricing mechanism, friends, we need to understand certain things. We need to understand. So, let me just, if you can allow me to share, I will just.
I think, Jay, you'll have to close down this and you'll have to give the sharing option to him.
Pricing. Let's just focus on a couple of minutes on pricing. Now pricing again, for unlisted, it is completely registered valuer has to do. For listed companies, ICDR is the. Now, for frequently traded shares, how does it talk about frequently traded shares? There is a pricing formula. What does that pricing formula Jay was explaining now? It is the last 90 trading days or last 10 trading days, whichever is higher, the price. This is in terms of a company which is considered to be whose shares are considered to be frequently traded. A frequently traded share is nothing but in the last 240 trading days before the relevant date, 240 trading days, if the volume of trades that have happened is more than 10% of the total shares, outstanding shares in the last 240 trading days, then it will be deemed to be a frequently traded company. Okay, in that case, pricing formula as prescribed by ICDR is what one has to follow, 90 or 10 trading days, whichever is higher. Then there is something called Articles of Association. I will come to that. And then valuation report, even in case of a listed entity, when do you have to have a valuation report? Is one, of course, in case of infrequently traded shares, it is no doubt it has to be some given by a registered valuer based on whatever the valuation models that he uses. But in case of a listed entity, is there a report? Where is there a necessity for a valuation report? Yes, it comes into picture on a couple of occasions. One, when in the post allotment, if somebody is getting more than 5%, then it has to be valued by a registered valuer. And post the preferential issue, if there is a change of control, then even in that case, you require a registered valuer's certificate in that aspect. Thirdly, in case of a swap of shares, when there is a swap of shares that is happening for a preferential issue, even in that case, a registered valuation report is required. The only thing is, in case of a change in control, the registered valuer he has to factor the control premium, which there is a way to calculate. So valuation comes even for a frequently listed when there is a change in control, when the post allottee, when somebody is going to get more than 5%, and when there is a swap of shares. These are the three occasions for a listed entity. Please be mindful of the fact, if the pricing formula calculated under ICDR 164 is more than this, that will prevail. So the higher of all these things is what is required to be taken. So don't just look at only the formula, but also please get into this depending on the situation in which you are in. Okay. Now listed entity, I just explained about this. The only thing is, previously, very rarely QIBs used to enter into the preferential offer space. But today, even the QIBs are coming into the preferential offer space. And hence, in their case, if you are offering it only to them in a preferential offer, not QIP, please. In a preferential offer, if you are offering only to QIPs, then QIBs, then the pricing formula is slightly different. Please be mindful of that fact. And in fact, if QIBs come and if they are the only subscribers, they have got a lot of exemptions as well from the regulations. as I said, and then consideration, can I pay other than cash? Yes, I can pay only but swap of shares. It's very clear from regulation 163 is very clear. You can't give anything else. So you can't give anything else in this. And if the valuation is not satisfied, stock exchange has got every right to ask for another. And it has happened quite frequently. It happens, friends. So when a valuation guy, when a register valuer does, he has to take into account so many factors, then arrive at this one. And so okay.
There is a question has been actually put to you, Ranganathan. Can you please also cover the valuation scenario under the FEMA where applicable?
What is the FEMA scenario in the sense? I'll just come. Let me finish my one flow and then let me take that question, please.
Yeah, sure.
I'll take that question. Now, let me tell you, friends, I don't know, whenever any person who is talking about a preferential offer of a listed entity should know what had happened in the PNB Housing Finance episode in 2021. This story we need to know, friends. This order we need to know. So PNB Housing Finance, I can go through each and everything, but just to, I'll only tell you, instead of. So just look at this. Floor price based on the ICDR formula was 384, whatever it is. And then actually PNB fixed at Housing Finance fixed at slightly higher, 5 rupees higher than what's the floor price. Because floor price is what? That's a minimum, right? Maximum I can fix anything. Okay. The book value turned out to be 540. So understand, this is a very interesting case, friends. So what typically happened was the EGM was supposed to be held. The postal, the notices were sent. The voting started. Actually, the voting started. So when the voting started on day one, at the end of maybe in the night, maybe I don't know the timing, 9:30, whatever it is, SEBI had sent a mail to PNB Housing Finance saying then to stop this issue or to price this at 540 and not at 390. So immediately when PNB thought what is the, because voting has already started and it will be completed in a couple of days. So what is the best way to go and do it is they appeal to SAT. Now the question before SAT was whether PNB, whatever it has followed based on the ICDR formula, is it correct? Or should they go through the book value, that was the question in front of. But there were added things also. Like the contention was that of SEBI was that post the preferential issue, if you look at the shareholding pattern, because the prospective allottees were a lot of private equity players. There are some 4 or 5 private equity players who together would be holding around 68%. And hence PNB as such being the holding company will be holding only slightly more than 20%. Hence, there might be completely a change of control in the days to come. Is the second one, and based on which SEBI refuted this. The third one was, which is the most interesting thing and which we all have to be careful of, friends, is the articles of association prescribed a particular way to arrive at the price of a share whenever they do a share issue. Okay. Now, based on that, it was coming to around 540. Now, the question is basically today, should I follow articles or should I follow ICDR formula? And that is why very wisely they will get a decision. So this is, so whenever we are incorporating a company, friends, or whenever we are doing a preferential issue as of today of a listed entity, please see whether your articles contain any provision to this extent. If it is so, then you have to consider that as well. And the higher of the price is what is to be sought from the prospective allottees. The issue should be made at that price. Basically, the legal question is whether articles should I go or should I go with the ICDR formula, was the question. Okay, now it went to SEBI. These were the proposed allottees, all private equity players. Okay, as I said, so change in control, all those things would come into play. And, there's a date of approval, all these things are fine. So the only thing whether, so in fact, please friends, when the electronic voting has started, SAT said the results will be kept in a sealed cover with the scrutinizer himself and not to release. All the shareholders were allowed to vote till the third day. So this is a very peculiar case where voting has started and some regulatory intervention can happen. Yes, it can happen. And what is the way out? So this also gives you that kind of provision. This case gives you that kind of a position. Now, finally, when it went to SEBI, when it went to SAT, there were only two members and it was a split decision. One was saying it should go with the articles. The other one was saying it should not, you should go with the ICDR formula. Okay. And now this is where the entire thing was left out. And finally, whatever said and done, they have to go through a consulment process and they have to pay whatever penalty to SEBI, and the matter got. But the question that arises is, having done all these things, for whatever 3-4 months of time and wasting everybody's efforts and the time frame, by the time share price would have also moved based on this, is it the correct way to determine was the question. So this is a very interesting thing, friends. Hence, the fallout of this entire case was articles. If a provision is there in the articles, you need to check what it says, and any change in control of more than 5%, as I said, it also requires a valuation report. And also, friends, being a CS, please remember, the independent directors are not supposed to meet only once in a year to determine your so-called performance evaluation. When it comes to a fundraising, they also have got a duty to do. And one such is, if there is a change in control, recommendation of committee of IDs is required. And it very clearly says all the IDs have to be present. Okay. So PNB Housing Finance, in terms of the pricing, has changed the pricing formula in ICDR. So effective 14 Jan 2022, if you see, the articles of association has also come into the pricing thing. So this I just wanted to. So please ensure that there is a, first and foremost, we spoke enabling approval for authorization of the preferential offer. So these were the learnings when you look at that PNB Housing episode. I just wanted to touch, since we are on the pricing aspect, Bala sir and friends, so this is one thing which we should remember. Yes, Bala sir.
Ranganathan, well said, actually. In fact, I always keep on saying, any company secretary who joins a company, first and foremost thing, he has to go through the fully article of association, be thorough, what is there, what is not there, over and above what is put in Companies Act, you should know. That is number one. Second thing is, anything which we are taking up a job, practicing company secretary, they also need to go. There is something which is over and above what is the Companies Act put in the articles. Because anything which is put in the article, because as per the, it's not violating any of the companies or not overriding any of the companies, right? You can build in, that will actually prevail. That is actually nothing but the internal charter duly approved by the shareholders of the company, how to run the company. So this you well said, actually. This PNB case was very, very popular case. It was there for quite some time in the news item. It was discussed and debated also. It was there in the news media also. It is nicely you have taken it. Thanks a lot. Actually.
Okay.
Those people who
So
are
one more.
not, many people may be aware. Those people who are not aware of it, it is really, really a good eye opener to them. Yeah.
So that's what, when you talk about private placement, friends, two things. One, Sahara Ekbar Padlo. Secondly, pricing when it comes to listed entities. Please read PNB Housing Finance order is what I would always say. Now, very interesting question which Harish is referring to. I was referring to ICDR 86 in terms of allotment too. Okay, let me tell you, Harish and other friends, is that the specific investor concept is a new concept that has been added in the rights issue. Now, what does it basically say? In case of a minimum subscription, if it's not able to, the company is not able to garner in case of a rights issue, then if the offer letter very clearly mentions about a specific investor coming and bridging that gap, then he is eligible to subscribe to that. And that will not be treated as a preferential allotment because it is a part of a rights issue. Now, what does rights issue, if you look at section 62 also says is that in case of if the company is not able, unsubscribed shares, if any, can be disposed of by the shares, which is in a manner which is not disadvantageous to the company, And accordingly, here there is a provision where instead of going for an underwriting, because the rights issue underwriting is not a mandatory thing. In case you opt, it's fine. In case you don't opt, you have the concept of a specific investor. Since it is part of the rights issue, the unsubscribed portion, it is not disadvantageous to the company, but I have already identified upfront who is the specific investor, so I'm giving it to him. Hence, it is not a preferential allotment. Harish, that's my take. Good you clarified. Good you asked this. Okay. Yes, sir. You wanted to ask something, sir?
No, somebody has actually put one question. He is referring regulation 167. He said the warrant which are actually unlisted are required to be locked in for the period of 1 year from the date of the allotment. Further, when it's come to the transferability, that is regulation 168(2), he is referring, the specific securities which includes warrants are not transferable.
Also, I think, see,
the trading approval section, regulation 167 regulation.
Yeah, got it, sir. Got it.
Yeah.
I think, see, what is the significance of lock-in and transfer restriction in terms of warrants? Basically, the restriction, why there is a restriction, why there is a lock-in. I think the concept of lock-in and non-transferability, is that, once you start selling it to, except, see, there is a difference, right? Within the promoter group, you can sell it if it is being subscribed by the promoter. But if you keep on allowing transferability of these warrants, then I don't think there will, because what is the purpose of specifying identifying a specific investor upfront and mentioning it in the explanatory statement or in the resolution, right? And hence, if it changes hands quite frequently, then you do not know where it will get into, and that's the reason there is a restriction on the transferability, hence lock-in. So that is how we need to understand. Now somebody is asking, I'm not able to, does the same principle apply in case of buyback? Which principle, please? Which principle? I think somebody has raised this. Jitendra, does the same principle apply in case of which principle? I don't know. If you know, please put it on the chat box. I'll answer. So let us know the valuation scenario under FEMA wherever applicable. So FEMA is also, I believe it is very clear. In case of listed entities, it says that please refer to the ICDR as per the ICDR. In case of unlisted, it talks about the registered. I think registered valuer, abhi tak they have not yet, I don't know whether they have included the registered valuer, but this requires a valuation to be given by a category 1 merchant banker. Friends, let me also tell you that the merchant banker, in case of a merchant banker, the merchant banking regulations have undergone a change. A merchant banker who is registered with SEBI cannot issue a valuation report. Now, everything has to be done only by a registered valuer. The only thing is FEMA should amend it. One doesn't know when it comes. Be careful in this. Don't go with category 1 merchant banker. Better to go with a registered valuer because merchant banking regulations have been amended. Just to tell you. So FEMA is, I think, unlisted valuation. If it is in the case of listed entity, go with whether still buyback can be done. Buyback. See, buyback and preferential issues are completely different, right? Buyback doesn't have any particular price. Whether fair value determined by registered valuer is less than the book value. Whether still buyback can be done at a fair value. See, it depends, right? Buyback doesn't have, whether for listed or unlisted, it doesn't have a pricing formula. Simply put it, in case of a listed entity, a company will initiate buyback only when it feels that the intrinsic value is much more than the market price. That's the time primarily, it tries to do a buyback. Don't get into there are different reasons why a buyback. Let's not get into that. But typically, if you look at from a financial and a strategic angle, when a company has some surplus of cash, then it looks into whether my intrinsic value of a share is much more than the market value, and then they decide. I don't think there is any restriction whether I can do at a fair value which is less than the book value. But my worth is whether, my feeling is in terms of a valuation principle, whether fair value, depending on the situation, I need to decide based on the valuation principle, Jitendra. That's my take at this stage. Unless otherwise, the circumstances are explained not in this separately. One will be able to identify, but I don't think there is any hard and fast rule denying this, but you need to look at the valuation principles. Friends, one more thing I just wanted to tell at the beginning itself. Sir, I'll take your a small 30 seconds for this.
Yeah, sure.
Please, friends, also remember, quite often I get a lot of queries where it says, "Bas, isme to nahi likha hai, isme to nahi likha hai. Where is it said I should not do this?" But please understand, every regulation, every act has some principles behind its framework. And especially company law has got a lot of principles, friends. You need to connect the dots. Today, me, is there doctrine of indoor management and doctrine of constructive notice in any of the sections? It is not. It is not. But can we ignore? The fact is we can't ignore. Please, friends, at least we guys should not get into that aspect of, saying that either if it is not there, can I do this? Please, you can do this, but link the dots, connect the dots very carefully, and then come to a conclusion is what my humble request to all of our fraternity friends. I just wanted to highlight this, Bala sir.
See, what is not specifically prohibited by the law, then taking into consideration of the situation, you need to take a call. Everything law cannot spell out actually. Law can only give the guidelines. That is the thing. Really.
Exactly.
Unless until it is specifically prohibited by the law, you can't do it. That's it.
Yeah, Krishnan, I think you are understanding what I explained. You had put it in the chat box. Thanks, Krishnan. Yes. Thanks. Good questions. I think
Krishnan is one of the very, very active participants and was quite interactive. I've been actually seeing him in the past webinars also. Thanks, Krishnan. I appreciate it.
You are seeing his only chat box, chat messages. Did you see him or
chat box only? Chat box only. See, no. Only chat box.
Okay.
Only chat box.
Okay.
He is quite interactive, and he actually gives thought-provoking questions actually. That is it.
Yeah. What is this? As compliance of preference required for issue of shares, how can we make easy complaints on additional company? Please, can you reframe this? Ask ChatGPT to reframe this and put it here so that I will be able to answer, please. Hanji. Okay. Jay, you can just do, then I will cover some orders later. You can just, okay. Sorry, Jay. I just.
No, it's fine.
Jay, we are already 12:30, yeah, going to, yeah.
Okay, so is it visible now?
Yeah.
Yeah, very much.
Okay. So we will be continuing with the price mechanism. As far as Regulation 164A, the price mechanism for the stress assets. Now, I would just like to give a brief that what is the stress asset. That if a company is going under the financial crunches or their credit rating is degraded, then SEBI allows to compliance with the few regulations. Not stricter regulation follow, and that issue is known as the stress assets. So for the price mechanism for the stress assets, if there is a frequently traded share, then a price shall not be less than 10 trading days of the volume weighted average price preceding the relevant date. The allotment condition shall be the no allotment even if one of the following condition exist, like failure to disclose details of forensic or repayment of principal amount of loan continuing for more than 90 calendar days after default. Then no intercreditor agreement in terms of RBI, and credit rating or is or have been downgraded to the D. Then section regulation 164A says on the compliance condition for the stressed assets. The issuer must also comply with the following condition, that the issue shall not be made to person not part of the promoter or promoter group. The preferential issue shall not be made to the following entities, that is which is insolvent under the IBC 2016, which is a willful defaulter or a fraudulent borrower, a person disqualified to act as a director under Companies Act 2013, that if a person is debarred from trading in security or accessing the security market by the SEBI, and a person declared as a fugitive economic offender, then again it is a post-allotment obligation for the straight assets covered under Regulation 164A, that if its violation is done, it should be a punishable offense with imprisonment for 2 years or more under IBC 2016, or for 7 years or more under any other law. Then guaranteed invocation means a person who has executed a guarantee in favor of a lender, and such guarantee has been invoked by the lender and remains unpaid in full or part. The proceed of preferential issue shall not be used for the repayment of loan to the promoter or promoter group or its group company. Proceed shall must be monitored by the monitor agency as well as audit committee, which we have already discussed in the previous slides. The lock-in will be for 3 years from the date of trading approval. And here the certification requirement is from the statutory auditor and audit committee. Then we talk about the price mechanism of the optional pricing under regulation 164B and regulation 165 relevant date and adjustment in pricing, that is regulation 166. So for the relevant date, 30 days prior to the date on which the meeting of the shareholder is held to be considered for the proposed preferential issue, where the shares are infrequently traded, then valuation parameters including book value, comparable trading multiples, and such other parameters as are customary to the valuation of such companies, provided that the issuer shall submit a certificate stating that the issuer is in compliance with the regulation obtained from a independent register valuer to the stock exchange where the equity shares are listed. Now, adjustment in pricing covered under Regulation 166, which says that we need to also take into account the capitalization of profit or reserve other than dividend in case for the demerger, right issue, or stock splits, whichever is classified. Where there is a change in control for more than 5% after the allotment, then any preference issue which may result in a change in a control or allotment for more than 5% shall require a valuation from the independent register valuer. Now here comes the lock-in requirement under Regulation 167. So for the promoter or promoter group, it should be the 18 months from the date of trading approval and not more than 20% of the total capital locked for 18 months. If there is any excess of the 20%, then it should be locked in for a period of 6 months. Convertible security or warrant which are not listed shall be locked in for the 1 year from the allotment. For the public and non-promoter royalty, the lock-in is for the period 6 months from the trading approval, whereas convertible security or warrants not listed shall be locked in for the period of 1 year. Where the company is under resolution plan under BIFOR or any NCLT, then the lock-in will be for a period of 1 year from the trading approval. Now, few of the important points are that if there is any entire pre-preferential allotment, then locked in from the relevant date up to the period of 90 trading days from the date of trading approval. As per Regulation 167A, it says that if there is any specified security held by the promoter and locked in, it may be pledged provided the loan has been granted to the issuer or its subsidiary for the purpose of financing one or more of the object of the issue, and pledge of specified security is one of the conditions for the sanction of the loan. The lock-in on the specified security shall continue pursuant to the invocation of the pledge, and the entity invoking the pledge shall not be eligible to transfer the specified security till the lock-in is expired. So next is transferability during the lock-in under regulation 168. So transfer of promoter lock-in security. So yes, subject to SEBI SAST disclosure regulation 2008 to 21, specified security held by the promoters are locked in terms of sub-regulation 1 of regulation 167 of this ICDR may be transferred among the promoter group or to a new promoter or person taking the control, provided that lock-in of such specified securities shall continue for the remaining period with the transferring. Trading approval restriction that the specified securities allotted to the preferential basis shall not be transferable by the allottees till the trading approval is granted for such security by all the recognized stock exchange where the equity shares are listed.
Somebody is actually putting a question when to apply the trading approval. Is it on the same day of the board meeting approving approval allotment?
Okay. Just to tell you this, trading and listing approval has to be done within 20 days of the shareholders of the allotment. It cannot exceed beyond that. See, in case of a listed entity, allotment has to take place within 15 days of the shareholders approval, right? And then you have got 20 days within which you need to apply for. So let us be very careful in two aspects, friends. One, in principle approval simultaneously when you are dispatching the notice of EGM or AGM to the shareholders. That is one. Second, listing and trading approval, you should apply within 20 days of allotment. And let us not, and there is no recourse for that. Hence, don't play with that. 20 days, is a very crucial thing. So let's take it seriously and do everything. Let's not wait for the 20th day to happen.
Raghunathan, I just wanted to know, practically, when you apply for the in-principle approval, does it comes in the normal time or it takes time? What is the practically happening actually in the stock exchange nowadays?
Sir, it both ways, but of late it has improved a lot. But it happens both ways as well. Both ways. In principle approval, at least you get an in principle approval because see what is the logic? When I go to the shareholders, I should have it in place. That is the logic with which I don't know the TAT what the stock exchanges have, but I think the logic behind that is you apply so that if you get it before the shareholders approval, and I think both the exchanges are quite good in that. Is what. But I'll also show one more order, friends, where not the listing approval, but not the in principle, but slightly the listing approval. Yeah, Jay.
So next is the payment consideration.
This
Under
I have
regulation.
covered. You can, for want of time, I think this I have covered, not 25%.
Yes.
Next is 75. This I had covered. You can just skip this.
Yeah, you can skip this slide.
Okay. So under chapter 5, the allotment under regulation 170, which says that allotment has to be completed within 15 days of passing the special resolution. Once the 15 days time limit is not applicable to the resolution passed under any scheme or plan. So if there is any company which is issuing preference share under any scheme or plan of the NCLT or IBC, then the allotment period of 15 days is not applicable. In case of regular company, if the allotment is not completed within 15 days, then again a fresh special resolution is required to be passed. In case of an open offer is required pursuant to SEBI SAST regulation 2011, the 15 days period shall be considered from the expiry of the period specified in sub-regulation 1 of the regulation 20 or from the date of receipt of all the statutory approvals required for the completion of an offer.
It is very simple. It is very simple, friends. 15 days from the date of resolution or within 15 days from the date of any statutory approvals that is pending. So whichever is later, that is what it talks about. Simple.
And allotment has to be only in the demat form.
Yeah. Yes, please. Go ahead.
So few are the case flows which we'll be discussing. So
yeah. One second. Can I just show QIP for 5 minutes and then we can...
Yes. Yeah, sure. Sure.
Please allow me to share that, please. So in terms of QIP, as I said at the beginning, friends, is because many companies, I think irrespective of whether IPO happens or not, QIPs will continue, friends. And hence QIP is also one of the things that you and I should be aware of. I'll just cover it in very brief. And this QIP is nothing but a preferential offer made exclusive to the qualified institutional buyers. Should I comply with 62(1)(c)? The answer is yes. Should I comply with 42? The answer is yes. Don't forget that that's a basic thing that you and I have to comply with. Now, if you talk about what it says, it's a quick way of funding. All those things are fine. The only thing is, there is this concept called minimum public shareholding limit, right? So there are a lot of companies which are yet to come to that level of 75%. There are different ways in which SEBI has mentioned you can come out with. There are some 9 ways in which a company can raise minimum public shareholding limit. And one such case is also through a QIP. Now, QIP in this case, and there is something called offer for sale through the stock exchange mechanism. Okay. One, if you are offering that offer for sale where anybody can participate, but if you are participating only to if you're offering only to the QIBs, then that is also in terms of it is considered to be a way of increasing the minimum public shareholding limit. Then in case of a preferential issue, the validity of that resolution is there for 12 months. And then you can come out with preferential. There is no gap unless otherwise the previous allotment is complete. But in case of a QIP, as I said at some time back also, within 2 weeks, the gap, it was 6 months. Now it has been reduced to 2 weeks. And only the promoter's director should not be economic offender, and at least for a 1 year it should have been registered. Now, in terms of the pricing, there is a pricing formula for this also. It talks about only the relevant date is nothing but the day on which the board or the committee for the question of there is a QIP committee or the fundraising committee which companies do constitute. The day they decide to open the issue, that's the price, that's a relevant date, that's the price at which QIPs can offer. Very interesting thing, Balasar, is even for the QIBs, you can offer them a discount of not more than 5%. For example, if I'm offering them at 200 rupees, I can give them, though the pricing formula is coming to 200, I can give them issue at 190 rupees. The only factor is I need to very clearly mention in this special resolution, friends. Please, I think the law is very clear. Many companies fail to do that, and then literally, they seek a lot of, help from the exchanges as to what to do this. So please be mindful. Here also the concept of monitoring agency is there. The only thing is type of instruments, equity shares, and here, as I said sometime back, non-convertibles along with warrants. Now, can I issue only warrants? In a preferential offer, I can issue only warrants, but here I cannot issue only warrants. Convertible securities other than warrants I can issue, but if I'm issuing warrants, it has to be in line or it has to be along with the NCD. So this is a very peculiar way of thing. And here the tenure of convertibles can be 60 months, whereas in a preferential it is not more than 18 months. And here there is something called preliminary placement document and a placement document, which is nothing but, you will get what are the contents of this is almost slightly, what do you call, the contents are more as compared to the past 4 requirements. But yes, ICDR gives you what are the different things that are required to be stated in this. Please be mindful of this fact. Again, you need to bring in the audited accounts and everything as a part of this placement document. So this is simple, but yes, many companies do go and do a QIP thing. So when a QIP comes, please be aware of the ICDR provisions. So now I'm requesting Jay to cover this ROC orders. Then I will talk on 2 orders of SEBI and then SEBI strokes SAT stroke Supreme Court. And then we will close with that.
Yeah.
Okay. Yeah. So is it visible?
Not it.
Yeah.
Yeah. Now
So
it is
the
visible.
So the first case is of the Chira Treaty Limited. ROC Hyderabad has passed that company. The fact of the case was the company overlooked the requirement of opening a separate bank account for receipt of application money received on the preferential issue. Then suo motu application was filed by the company, and ROC penalized the company and its director of 1 crore 20 lakhs. The second case was on the Born Fresh Food Private Limited, ROC Chennai. The fact of the case is the company has issued the CCPS, that is compulsory convertible preference share, by a preferential allotment without obtaining a valuation report under section 62(1)(c) of the Companies Act 2013. Again, the company has suo motu filed the education application, and the ROC held that the company was a startup registered with the DPIIT. So they have levied the penalty under section 446B of the Companies Act. ROC penalized the company and its director of rupees 15,000. Then the third case is of the Vijaya Hospitality Resort Limited versus Tony, NCLT Chennai. The fact was the preferential allotment without complying with section 62 rules and rule 13 due to order passed under section 241, 242 of the Companies Act. The fact where the allotment on shares of the preferential issue by pursuant to the order passed. The company was in thought that they need not to comply with the regulation, section 62. The NCLT held that the merely passing the order under section 241 does not implies that the company does not want to follow the section. The company has to follow the section procedural mentioned under section 62 while doing the preferential allotment.
Yeah, so I will just take it over, Jay.
Raghunath, one question before you say about
Yeah.
the questions. When it comes to the separate bank account, suppose the company is having a bank account. There are two bank accounts. One is actually used for the day-to-day operation. Other account is virtually not used. It is open for some purpose. It is lying like that. So instead of opening a separate bank account, they thought that we will utilize this particular bank account for receiving the money and other things and all those things. That is what they thought, and they do it. Is it okay or it is not okay?
Sir, okay, it's not an opinion, but just, so there are two things, sir. It is, you need to compare this with dividend, opening a separate bank account for dividend. So every year when a company declares dividend, you open it because there are a lot of shareholders. So you have a different account so that reconciliation becomes very easily. Simply in a layman's language, if I say it. But when it comes to this bank account, the reason for this is it is now attached to utilization of funds, right? If it is clubbed along with the normal bank account, how will you monitor? That is the biggest.
No, he is not. He has got a separate account for day to day. He is not using that. He has got one account which is not in use, which is only like a minimum balance.
You can use it, sir. I think you can use it. It only says as news. It doesn't say every time you should open a new separate bank account. You should have a separate bank account. The ultimate purpose is what? Am I able to link this issue proceeds with that bank account? So simple. So if I have a bank account, if I'm doing a preferential issue today and I have deposited say 100 crores of rupees in that, and I have utilized it within another 2 months, I have utilized it. And come next, in the 5th month, I'm doing another preferential issue. Can I use the same bank account? The answer is yes, provided you had completely utilized that. I think there is a way out. It only says a separate bank account. Separate bank account is to be opened, but depends on, whether you have fully utilized. My only request is let the funds which you had already transferred in the first time to that separate bank account, let it be fully utilized. To answer you, sir, if it is a separate dormant account which is here, you can use it. You can use it. I don't think, but be specific for this. Your resolution should very clearly indicate that this I'm using this bank account number XYZ with this branch for this purpose, and that is how you can do this. Okay.
I agree with you because very recently in one of the company called Digilogic Limited, which is the Telangana based company. What they have done is they have utilized one of the bank account like that only. Their resolution also said the same. they will be utilizing it. But ultimately, a certifying professional who had come, he said, you have not opened the separate bank account. So you have violated the Companies Act. So you have to file a suo motu application. So they did not have the company secretary. So naturally, they filed the suo motu application. When they filed the suo motu application, there's a whopping amount of 8 crores. That means 2 crores for the 3 crores for the, I think, company, 1 crore each for the people. 8 crores fine have been penalized, I think. That's what they've done. So after that, they were shocked, actually, 8 crores. When they discussed with one of the senior professionals, he has gone through the issue, he advised immediately make an appeal. Matter went to the appeal, Hyderabad RD again. Then they are able to explicit very clearly. He said, we did not have the professional advice, we did not have the company secretary, we have been wrongly advised. The managing director is only a technical person. He is not aware it. He simply got by that, filed it. But the ROC seemed to have told, suo motu, you have come, you have said you have violated, you cannot go back. That is what he put the argument in front of the RD. RD said, sorry, we are not here to collect the fines, but we are here to regulate and the compliance is done. So long as they are able to very clearly exhibit, they had a separate bank account, they are able to separately show this, it can be done. That is what this classic case has actually come very recently. I saw this case actually. Yeah. Really speaking, as you said, although this is only a 2 sections, it is only a few things, it is, very simple. It is not that simple. There are a lot of intricacies, lot of application, lot of interpretation, lot of understanding, which is actually calls for in this, for both in working people and as well as the practicing people. Yeah, go ahead with your case, please.
Only one questions. Is it required to go for valuation if the NCD is issued at par? Now, friends, let me just tell you one thing. The main feature of an equity share is the valuation. I think only the equity instrument creates value. And hence, we always talk about valuation in terms of the equity. So NCDs, whether it's a valued at par, in case of a debt instrument, it is the interest coupons that you pay, how you determine. It's not the, valuing that particular NCD. It is the interest coupon. Yes, the only thing that you can come is, can I redeem the NCDs at a premium? Yes, depending on whatever the conditions, do it. But there is no concept of valuing NCDs. The only exception I can find in terms of NCDs and redeemable preference shares is NBFC's prudential norms has got something to do with this only for that particular purpose. So there is no concept of whether I can issue at par. NCDs are not really valued. It's the interest coupon rates that you need to determine. It's again value determine. I'm saying bank account we discussed. Also, there are many procedures for separate. So can we have a separate for all this? No. Please, either can we maintain a single separate account for all these sections requirement excluding? Sir, this question, this will demand 80 crores of penalty.
Correct.
Not Correct. This, whoever has done this, it doesn't. See, can you club dividend account and IPO account together? No, let's not be on that. It's a simple thing. Yes, we will be in a position to do. I know the finance guys will create a trouble, but yes, do you have to open a separate bank account? So far, it doesn't say separate bank accounts for a rights issue. But friends, understand certain things. There is, so long as you are able to demonstrate that the money has come in from this, then the things are very clear. Even rights issue will require a monitoring agency if it is a listed entity, right? How will you demonstrate? I think it's more of operational convenience that we use a separate bank account rather than a regulatory imposition on us, friends. I think we should consider, in case of a price, can we issue shares at price below the price valued in valuation report? See, again, valuation report is what? It gives you a particular thing, the base price, right? So irrespective of whether it is private or a public, I'll have to go only with the valuation report. That's the minimum thing that it will talk about. Okay. So I'll just show some 2 interesting cases and then we can wind up, sir.
Yeah, sure.
Just allow me to share. Yeah, thanks. So very interesting thing which has happened. It's only an interim order that SEBI has passed. In this case, Drone Acharya. It's a Pune-based, FOSD-based company. I'll just tell you a very simple thing. It's a SML listed entity, and they had misutilized the funds that have been raised. And so when it came to the notice of the regulator, they have debarred the company from from accessing the capital markets. Okay, that's a simple statement, and it's an interim order. But in the meantime, what had happened is, since it's a drone and they have got a lot of orders from the government, from the defense ministry, they have to honor that, and hence they needed some more funds during this period, and hence they went to SAT and said whether can we, pending this appeal, pending this order, disposal of this order, can I go and do two things? One, can I issue NCDs? Second, can I do a preferential allotment? And the third one is, the promoters also pledging their shares and giving the money, because even the promoters were debarred. The very beautifully, very practical thing which SAT has taken in this case, and they said, pending the final decision of this order, and they had also demonstrated or showcased the very clearly what is the demand from the defense ministry, and hence SAT very clearly allowed it to do raise funds and during this interregnum period as well. So that is the that's one of the very, Bala sir, I would feel that it's a very practical thing which SAT has said, and we should welcome this. A lot of penalties wo sab chhod dijiye, but the crux is, if you can demonstrate, will regulators, yes, regulators will allow. So whatever this, that's the crux of this drone Acharya. If you can't read this interim order, you will understand. Even though the promoters and the issuer has been debarred from accessing the capital markets, but can I do it for a business perspective? The answer is yes. That is what this order shows. Okay. Then Supreme Court order, friends, we should all be aware of this aspect, and let's take this very seriously, especially this order. So typically, again, in Terrascope Ventures, what had happened is, diverted the funds for other than what was stated in the objects of the issue. Now, one second. Now, if you look at the object of the issue was to fulfill the additional fund requirement for all these things. But where did they divert the funds? They diverted the funds for purchase of shares and granting of loans. Now, if you look at to whom they have given the shares or given the loans, it is all to a common guy and who had funds. One second. Money diverted to investments in unlisted companies and loan given to connected entities which had common promoters. Okay. Now, what had happened is, when they made the issue, the objects clause did not contain the provision for making investments and giving loans, etc., etc. It did not contain any kind of a thing. And rather than, so the question that came to mind was two things. And very clearly the company later on amended the memorandum of association to suit this object for which they have diverted the funds. The question that came, and they went to shareholders and they got ratified. Sir, they got ratified the resolution which was passed as an object of the issue. Then in fact, SAT had very clearly said that, once the utilization is over and other things, you can go ahead and there is nothing wrong, is what SAT has pronounced. But if you look at what SEBI has very clearly said, during the issue time, you had given some objects which is not reflected in your memorandum and articles, and can you go and do this? And they very clearly varied this post, the interim order, which ex parte order, which SEBI had passed, the whole time member has passed a order, and they tried to do this. So SEBI's contention was very clear. And SAT somehow or other took a different dimension, and they said, since the entire proceeds are used, there is no need for anything. So I think it is in line with whatever it is. But SEBI went to Supreme Court. Now this is the question. Can a ratification of an event which has already been done and you had utilized the money to whatever extent, the entire extent, can I change the objects because shareholders have approved initially something? Can I change it now? Is the question before Supreme Court was, so this is the question which can shareholders ratify a decision which already they have concurred with. Okay. Now, money where a company does an act which is a no legal relationship, this is what Supreme Court is saying. no legal relationship or ensures such an act is absolutely void and cannot be ratified even if all the shareholders agree. Couple of things which they took, one, in terms of variation in the, if you look at section 27, it talks about variation in the proceeds, which you can do after an IPO, but that is focusing only on IPO, friends, not in terms of any other preferential offer or allotment. So it was restricted only to to a public issue and not to preferential issue. So when the Defense Counsel wanted to do this, he had mentioned about section 27, but Supreme Court was very clear saying that it applies only to an IPO. So there was heavy price movement on this. What is the impact on the shareholder? For example, it had analyzed different cases based on this object, whether I should invest new or I should add on to my portfolio or I should sell. Everything I think Supreme Court considered from the interest of the shareholders, and they came out with a very beautiful concept between waiving of a private right versus waiving of a public right. This was also another point which Supreme Court very clearly analyzed. And finally, it said that ratification of a shareholders resolution is invalid. However it may be, the shareholders, once they had passed, they cannot go and ratify. And in fact, the question also raises whether it was doctrine of ultra vires when they did this. So
absolutely correct. Absolutely correct. That is what you touched upon. You nailed it very correctly. No ratification can be done. That is very, very clear.
Another interesting case, sir. Just I will finish with this. Jet King Info 10. Again, you asked about the in principle approval, how quickly all those things, they had applied, whatever it is, they had granted an in principle just within whatever time, within the limited time frame. Then they had utilized the proceeds. Then when they came to listing, when they applied for listing, BSE rejected it. Why? Because when they applied, they had altered the memorandum. So now, friends, I think we as company secretaries should know this, friends. Amendments to, they had made 2 amendments. They made the first amendment and they went for objects of the issue and they did that. But actually, when they had mentioned the objects of the issue was different from what the first amendment turned out to be in this case. Now, when it went to the SAT, it very clearly said that there are 2 things we need to consider under Schedule 3 under the memorandum. One is Clause 1 and Clause 2 of the memorandum, which talks about, one is the main object, second is furtherance to this. This guy, first amendment when they made, it was part of the ancillary object. Okay. Now, food for thought for all of us, friends. It was part of the ancillary object, but actually they started doing, and the second amendment they did for, to include whatever is there, whatever they want to do as a part of the main object. They were trying to convince the regulators saying that it is part of this, but regulators were very clear. At that point in juncture, you did not have it. You had it as a part of your ancillary and not as a main object. And hence that was, that was completely rejected by BSE as well. BSE has very clearly rejected, Now the question to all of us is, so if there is something mentioned in the ancillary objects, should I not raise money for those purposes? Is the food for thought for all of us, friends. Okay. No, because all these things are very interesting cases. I just wanted to give you a flavor of what is happening in the listed space as well. So just these are a couple of things which I thought, let me share for this, friends. So, sir, broadly, these are the things which I just wanted to cover. So I missed it. Who is missed it? SCK, Supreme Court order. Go and look at the Supreme Court order on what do you call which company? Terrascope Ventures Limited, Krishnan. Or you talk to me, I'll send you that order. You can have my, anybody, see, as rightly Bala sir pointed, it's not a opinion seeking, but any kind of professional guidance, you can always at least call me, just to, all these things we can, so it's a Terrascope Ventures Limited. You can look at, what do you call, you can Google it also, Krishnan. Just put that Supreme Court order, Terrascope Ventures Limited. You will get it. And please read. And Terra Ventures case is one thing. Jet King also objects of the issue, how memorandum plays a crucial role is what you and I have to understand. Hopefully we have answered. I don't know. I mean,
You answered all the question. I just run through. You have done everything. Excellent, Raghunathan. In fact, two things which came out to my knowledge. One thing is nowadays regulator are not concerned in interfering in the business matters of the company. Business is yours, you run the business you way you want it. We are not going to interfere in your business so long as you do the right thing. That's all. If you don't do the right thing, yes, we are there to step in. Because this is a very eye-opening case, what you brought out with the set which gave the permission to the Dronacharya's case. I also read that case actually. In fact, I was really amazed to see because it is reconfirmed. The regulator is not there to stop your business, especially at this particular time when more and more government initiatives coming, startup are being encouraged. We are working, self-sufficiency, the Atmanirbhar scheme, Viksit Bharat 2047, all those things which are all happening. Regulators are also becoming more cautious nowadays. They are not interfering in the business affairs. The business affairs, you do it whatever you will. Similarly, when you come to the valuation report, etc., and all those things, they are not going to question you why this value, why that value. They are not going to question. Only thing is methodology. Have we followed the right methodology? As you rightly put, you have put in the article, you have put in the ICDR, which is holding good. That's all we are concerned. We are not concerned. If you would not have put it in the article, we would not have come back at all. That is what they are saying. They are only questioning a procedural issues, not the valuation per se itself. Again, when it comes to the valuation, very clearly, I am clear in my mind, valuation report is actually a judgmental things, which are actually coming by the professional person who was given to the board. It is the board to decide what is the valuation, what is the thing in their best wisdom. They are running the business of the company. I am very clear on that. These are the learning which I picked up actually from you. Excellently, you shared your knowledge. Excellently, you brought out this issue. Also, it is a very, two small sections, what you are talking about it. I also thought, oh, it is too small. So what is going to be the way in which the interactions is coming, the questions are being put up. It actually shows what are the various intricacies which is there. We need to really, gear up to the situation. We need to really become, especially when you are getting more and more recognition, when you are actually calling ourselves the corporate strategic advisors. We are not no longer a company secretary. We are actually a governance professional, which we are going to be. So I think we need to raise our bar. That's what I would say. With this, I leave to your last few words, Raghunathan. That's all. Then we can close the webinar.
Okay. So I'll just reiterate only a couple of points again for all of us friends. Is I know I had attended a free webinar and I say a couple of months. Can you please share? I have shared my number, Harish. I have shared this number again for want of. If you want, again I can.
It's already appearing there. He has already put it to 2 or 3 message before it is there.
Yeah.
Yeah. Again, he has shared.
Yeah. So okay. Anyway, so we cannot able to see in our chat window. That's why we can see only your questions and not the replies. Acha, not the replies. No. So anyway, 98202 88054 Krishnan and others, if whoever wants to, whoever is still active and alive in this session, 98202 88054. Okay. So just to conclude, friends, for the, after a long time, I'm seeing some very beautiful questions that have come out, and that is where, believe in ourselves as the best interpreter of corporate laws. Secondly, there are some principles, please write mobile, no repeat. I don't, anyway, so second thing is also connect the dots. There are a lot of principles within a regulatory framework. You and I cannot just simply say that, it is only this regulation and that regulation. You need to connect everything together, because we as a company secretary, when we are supposed to be whatever, the internal regulatory guy sitting in a company, we should be in a position to give the comprehensive view of whatever is being requested by the management to do it, because ultimately the business should carry on. So I think we as professionals should be very effectively support the organization in their deals. And small things which it comes with requires a lot of education to the promoters and to the other colleagues in the team. But let me put it this way that what do you call? Believe in yourselves. We are the best guys to interpret corporate laws. Bala sir, I would repeatedly say that because the lack of confidence is what is bothering all of us. But as friends, rise to the occasion, and we are no more the same people who are, because now the Companies Act and everything is being interpreted. People have started reading this. Pehle to nobody was there, but now everybody is reading and everybody has their own interpretation. But the beauty of our profession, only experience will tell you. When you connect the dots, nobody can beat you when you put a very technical response to so many things, friends. So with that note, sir, I think thanks to Mehta and Mehta, Jay, yourself, Disha, and everybody for organizing this. And thanks to Disha for calling me. Yaad se she called me, So thanks a lot.
Thanks a lot. I take the opportunity of thanking. Yeah, thanks a lot. I take the opportunity of thanking Mr. Ranganathan for his valuable inputs and practical insight and making the session very live with the interactive, etc. and other thing and that. As I said in the beginning, he's a good friend of mine. I know him very well. In fact, he is exemplary. Any topic, he can talk in the dream, the night, and the sleep also he can talk. That sort of a thing. Today we have the privilege of having him. It's things is very good actually. And I would also like to thank to Jay who brought out very lucidly the various provisions and nicely put up and presented and printed. He has done a very good homework. Thanks to Jay. Lastly, thanks to all the participants who are here at this particular time. I can see 127 people who are there. As I said, I am highly, highly delighted to take note of it. The interest which is actually coming from the people who are actually, wanted to learn new things, etc., enhance knowledge. I'm very grateful. Our profession really reached the high. I wish for that. Thanks a lot. We close this session with this note, and we yet meet another session the next week. Thanks. Thanks a lot.
Thank you.
Thanks a lot, sir. Thanks a lot. Thanks, Jay.
Thank you. Thank you, sir. Thank you.
Have a good weekend to everybody. Thank you.
Yeah.